Hello, 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 and happy Saturday, everybody. How is everybody doing? Kate Bell, Kate Mitch, Sister, Fruit Fly. Hey, Fruit Fly, long time no see. How you doing? Nana, hello, hello. Dawn, hello, hello. Hello. Good morning, good afternoon, good evening, depending on where you guys are. Okay, let me just get this set up here. Get this shared so we can go over this. There we go. Okay, a lot of documents, you guys, have come out in the Bryan Kohberger case. His goose is cooked. If you guys haven't smashed the like button, please smash that on your way in. It helps get us out in the algorithm so we can get going. Dawn says, before it gets too busy, I sent a message to the lady who's missing her daughter from Waterloo and she never got back to me. Huh. That's odd, eh? Well, at least you tried, Dawn. That's all you can do is try. Okay, so we've got, let's see, 1, 2, 3, 4, 5, 6, 7 documents that we're going to go over, you guys. These were just filed on the 24th. They didn't hit the docket until yesterday. I was going to wait to do these until Monday, but the reads, I recorded 2 reads this morning, and then when I went to upload them, I didn't save them. So I lost them. So I'm going to have to do them over again. But it's going to be interesting to see what comes out. Okay, so the first document that we have is, these are the orders. If you guys were here for the April 9th hearing on all the motions that were heard, the judge took a lot of them under advisement. And these are the orders that he has come back with. And to me, I said this, oh my gosh, sister, what, about 6 months ago, I said, you watch. They are trying everything to get evidence thrown out, to get the death penalty off the table. And they are even trying now to postpone the trial yet again. So I don't think it's going to fly, but we're going to have to wait and see. Now, there's also, we've got the ASD, the autism spectrum disorder that he's now trying to claim. And that's gonna like to deter from the death penalty because he suffers from this mental illness and all that shit. We'll get into it. Well, my question is, what happened to this white snow thing that he had that you guys were going to use? Okay, so they're going to talk about this, the undisclosed expert testimony. They're going to talk about the DNA. They're going to talk about the bushy eyebrows. They're going to talk about the text messages and 911 calls. There are some that are going to be redacted. I don't think they should be, but that's the ruling. We'll go through those and which ones are going to be redacted. There's a summary on the orders of the motions. And then they talk about the psychological evidence and the ASD evidence to try and remove the death penalty. Now, apparently, from what I have heard, um, is Idaho is now going to be using firing squad. Everything is set up for it. It is now a viable option, whereas before, even though that it was part that was brought into law that they could use the firing squad, they weren't set up nor prepared for it. They didn't have a facility for it. That facility is now available for to carry out the death penalty sentences. So if he does get the death penalty, right now it's set for firing squad if he gets the death penalty. But we know when you're convicted and it's a death penalty case, it's an automatic appeal, and he could go on appeal for over 20 years. And now, also from what I've gotten through the grapevine, is his mother is throwing a monkey wrench into the defense. She is saying, absolutely, you are not taking a plea. You're going to court. You did not do this. You're going to court. So to me, it's like, as a mom, if he could get the death penalty off the table, would you not want that for your son? Why is she throwing a monkey wrench? Like, nope, you're going to trial. You're going to trial. Because in an appeal, there's not going to be no offers, right? If he's found guilty and gets the death penalty and appeals it, there's no option for making a deal now to get the death penalty off the table. Like, you're setting your son up for failure. You're sending your son to the firing squad is what you're doing, what you're pushing for. But she is under the assumption he's innocent. He did not do this, and she's standing firm on that. The father also, I was thinking that maybe it was going to be the father that they were going to bring in to testify. I've kind of wavered on that a bit. I think it's going to be the two sisters, because I got word that the two sisters apparently, and we covered this before, were making comments saying, look, we think Bryan is the one that did this. When they came out with the description of the car and this and that and whatever, they thought right away that that their brother could have been the one that did this. And they went to their parents about it. The mother outright freaked out and like, how could you think that way? And the father just walked away. He didn't want to hear no part of it. So I think if they call anybody, it'll probably be the sisters. Now, the sisters have really suffered because of this also. They both lost their jobs. One was a psychologist and one was an actress. Now, I don't know if they've secured other employment. I'm sure they have by now. But they took a hit because of him too, right? One of the sisters, he stole her phone and stuff like that, like back in the day. Whatever. But anyway, enough of that. We've gone through most of that. But what I'm, really wondering about with these documents is they are fighting that he has a mental illness, ASD, which precludes him from getting the death penalty. It saves him. Well, they did a psychiatric evaluation, and they go through that. We'll go through those documents, but I just wanted to get this out here because you guys know me, my memory, I'll forget. nowhere in them documents are they talking about this white snow that he claimed to have, right? And you can see as we go through these documents, keep in mind, see and watch what the defense is fighting hard on, because that tells you a lot. That tells you that is evidence that they know is damning and is gonna sink him, right? So let's get going. Now, what I've done is a lot of these documents are very extensive, these orders that the judge has made. So I've gone through and highlighted the important parts in them. There's a lot of citing of cases in law and this and that we really don't need to know about, but I will scroll through each document. So if you do want to read the entire document, it will be on here for you to read later. You can go back and read it once we're done, and it's posted on my YouTube, and you can scroll through it at your leisure by pausing it and reading everything if you so wish. So I will do that and scroll through slowly for you guys so you can do that with each document if you so wish. So let's get going. The order on defendant's motion in limine. Okay, the vague and undisclosed expert testimony. So, introduction. Defendant moves, so this is a defendant's motion that they had made, moves to limit or exclude several different experts disclosed by the state on grounds that their disclosures are deficient in some regard. Hang on a sec. Sorry about that, you guys. Allergies are through the roof. So if I have to pause for sneezing and that, please bear with me. My nose is stuffed, my sinuses are blocked, my eyes are itchy. It's horrible. Okay. The state responds that it has complied with all discovery obligations and its disclosures are sufficient. It adds that several of the defendant's challenges are fodder for cross-examination, not exclusion. Oral argument on the motions was held on April 9th, after which the court took the matter under advisement. The court finds no basis to exclude or limit the disclosed expert testimony at this time. But if the defendant believes an expert is testifying at trial outside the scope of his or her disclosure, he may object at that time and the court will consider it. So I am going to scroll through this. There are some parts in here that I've highlighted, but like I said, I'm going to scroll through so you guys can read it if you so wish. She's delusional, yeah. Yep. Okay. So, the analyst. Rule 16b-7 requires the state to provide, upon written request of the defendant, a written summary or report of any testimony that the state intends to introduce at trial that qualifies an expert witness testimony under IRE 702, 703, or 705. The disclosure must include a summary, just a summary, not everything that the witness is going to say, but a summary, right? The witness's opinions, the facts and data for those opinions, and the witness's qualifications. ICR 16b-7. When the party fails to comply with discovery, the trial court may impose sanctions, including inappropriate circumstances, the exclusion of witnesses, and they're citing State versus Wilson, right? So, Jeannie Ayers. Jeannie Ayers is a forensic scientist with the Idaho State Police Forensic Services who works in evidence collecting and crime scene processing. She is disclosed to testify in the state's case in chief about crime scene processing generally, including collecting DNA, blood stains, latent fingerprints, hair and fibers, and shoe impressions. Now, they go into a lot of detail here. Like I said, I'm going to scroll through. I've highlighted the important parts, okay? Defendant's challenges misapprehend the type of expert Miss Ayers is. Much like law enforcement, Miss Ayers is a hybrid fact expert witness as opposed to a traditional expert. She will be educating the jury on crime scene investigation procedures to provide foundation for her testimony regarding the work she and her team performed in the case, as outlined in lab reports 25 and 11 and the accompanying field notes. Her testimony will be allowed as disclosed. Special Agent Nicholas Balance. FBI Special Agent Balance was primarily involved in the analysis of cell phone records in the investigation. He is disclosed to testify in the state's case in chief about his analysis of AT&T cell phone records for the defendant Madison Mogen and Zaina Kernodle, as well as his own drive testing measurements to determine the use and general location of their cell phones between June 2022 and November 2022. And I find it weird, you guys. Let me know what you guys think, because he is disclosed to testify in the state's case in chief about his analysis of AT&T cell phone records for the defendant, Madison, and Xana. What about the other ones? Right? I don't know. That's something there. Do they have AT&T cell phone records that show Bryan Kohberger in the same exact locations as Madison Mogen and Xana at many different times? Remember, they said now that there's 23 times that he was in that area. Accompanying his initial disclosure in his 30-page CAS report, which discusses and maps the data he reviewed and the methodology employed. What's this here? For example, the disclosure discusses why the team focused on certain areas of the home as opposed to others, why they decided not to collect mattresses and bed frames, and why they swabbed and or applied amido black where they did. Because up here it says, with that testimony by Ayer, there's a footnote here. For example, the disclosure discusses why the team focused on certain areas of the home as opposed to others, and why they decided not to collect mattresses and bed frames, and why they swabbed or applied amido black where they did. See? And this balances, including those related to the defendant's locations at the outlined times before and after the homicides. Okay. So like I said, I'm going to just scroll through this, but I just seen that out of the corner of my eye, so. Defendant, however, asserts the attempted clarification in the rebuttal disclosure is insufficient, arguing there was no disclosure. This is where the judge flipped out on the defense in the April 9th motions hearing, where Cy Ray basically called out Agent Balance and said he didn't do the proper job, and the judge said that's reason for disbarment. Anyway, okay, so the defendant, however, asserts the attempted clarification in the rebuttal disclosure is insufficient, arguing there is no disclosure as to why he has omitted 95% of the relevant coverage maps for his drive testing, no analysis or mapping of the handoff data, and no documentation provided of the CAS report's peer review process. However, the fact remains that the defendant has all the facts and data that Agent Balance relied upon to form his opinions, which are expressed within his CAS report. While his methodology might not be set forth with much, we'll get back to this here, with much specificity as Mr. Ray would like, Rule 16 does not require that detailed methodology be provided. It requires merely opinions, facts, and data for those opinions and the witness's qualifications. To the extent the defendant believes Agent Balance omitted important data or is relying on insufficient data for his opinions, this is fodder for cross-examination, not exclusion. Moreover, if an opinion is not reasonably set forth within the disclosure, it will not be allowed. So they are not going to allow Cy Ray to get up there and do what he intends to do. He basically thinks that he's better than the FBI. So here's the footnote. Mr. Ray notes that Agent Balance failed to include an analysis of his handoff data for the defendant's cell phone between the hours of 2:30 and 3 a.m. on November 13, 2022. That he did not include the mapping he relied upon to establish the defendant was near the crime scene on several occasions before the crime, and he failed to disclose how his drive testing works to a sufficient degree. So it's like Cy Ray, this little nothing guy who's been uh, we've gone through this with Syra, you guys. You look at Police Off the Cuff and Duty Ron and all them, and some of the lawyers that are on YouTube have all said that the courts have tossed his testimony because it's junk science, but he still thinks he's better than the FBI. But anyway, he's not going to be allowed to get on the stand and say that Agent Balance didn't include anything and stuff. We heard about this handoff and data and stuff that's only available for seven days. And by the time they got Bryan Kohberger as a suspect, like over a month later, that data was no longer available. Okay, so Heather and Jared Barnhart. The Barnharts are digital specialists with Celebrite who were retained by law enforcement to analyze the defendant's cell phone and PC to determine user behavior and actions. They are disclosed to opine that the gaps in the data on the two devices were abnormal. Attached to the disclosures is a report jointly authored by the Barnetts detailing their analysis and findings. Their CVs were provided as well. Defendant argues that the disclosures indicate that they will testify to habit evidence, which he complains is not explained and is not accompanied by any opinions. Defendant's challenge is confusing. Nowhere do the disclosures or the report indicate the Barnharts would testify about habit evidence. Rather, the disclosures state that they will testify to their findings pertaining to the defendant's activities on his PC and cell phone for a period of time before and after the homicides, and why gaps in data over that time period are abnormal. And there's a 10 here somewhere, right here. There's this 10. So 10 down here. Specifically, the report explains that the gaps in data may be consistent with cleaning up or using anti-forensic methods to clear evidence. So they feel like he's gone in and removed stuff off his phone and computer. And he would have learned how to do that in his studies, right? Hello, Carolyn. The Barnhart's opinions regarding these topics are fully set forth in their joint report. For example, they observe gaps in the defendant's school PC that may be consistent with cleaning up or using anti-forensic methods to clear evidence. Among the gaps found were in the PC's event logs and system resource usage monitoring between November 11th and November 16th, which Barnhart's opined was abnormal given that the school was in session. Likewise, they located gaps in the PC's Chrome history during dates where downloads occurred on the system, indicating the user was private browsing or clearing browsing history. Together, the Barnharts disclosed and joint report set forth all that is required by ICR 16b7, and there is no basis to exclude or limit their testimony. That is going to be so damning to Bryan Kohberger, because this part right here, among the gaps found were in the PC's event logs and system resource usage monitoring between November 11th and November 16th, which Barnhart's opined was abnormal given that school was still in session. Likewise, they located gaps in the PC's Chrome history where downloads had occurred. So they seen there was downloads on the system, but it indicated the user was private browsing or clearing the browsing history. Okay. Michael Douglas. Mr. Douglas is a forensic accountant for the FBI and is disclosed to testify to financial transaction data for the defendant, the 4 victims, and the 2 other roommates. The defendant contends that Mr. Douglas should not be able to offer any opinions because none are expressed in the disclosures. Specifically, defendant notes that Mr. Douglas's supplemental disclosure indicates he will testify to an analyst of the defendant's spending habits. Defendant takes issue with this, arguing there is no spending habit opinion disclosed. Good morning, Charissa. However, sorry, I just took a drink of my coffee here. However, Mr. Douglas's disclosure makes clear that he is intended as a fact witness and is only being disclosed as an expert in the event the court determines his testimony was based on specialized knowledge under IRE 702. Moreover, although the supplemental disclosures appear to indicate he will offer an opinion as to the defendant's spending habits, his testimony will be limited to factual changes in how the defendant spent money. For example, the disclosure notes defendant only conducted ATM withdrawals on and after the date of the homicide and ceased using his debit card after November 10th, whereas prior to November 10th, he had regularly used his debit card. There is no indication he will attempt to opine about the reasons for spending changes, just that they occurred. Thus, there is no basis for excluding or limiting Mr. Douglas's testimony based upon disclosure concerns. Shane Cox. Mr. Cox is a litigation and regulatory manager for Amazon. His initial disclosure states Mr. Cox will testify to the content of documents produced by Amazon to law enforcement pertaining to an Amazon account associated with the defendant. There is no basis for the exclusion of his, and he's going back with the content of documents between January 5th, 2022 and December 13th. Don't forget, he bought that K-Bar knife on Amazon. I think it was in March of 2022. And then he again searched for one after the homicides. Okay. Darren Gilbertson. Defendant disclosed expert opinions from Brent Turvey that more than one assailant. Okay, so this is for the defendant. Defendant disclosed expert opinions from Brent Turvey. So Brent Turvey is a defense expert, apparently. This Brent Turvey is saying that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, he asserts that 1, there is direct and indirect evidence that attempts were made by the suspects to clean up the crime scene after the homicides. That's something new that we did not know. Apparently, this expert of the defense says that the perpetrator attempted to clean up the crime scene after the homicides, which would have taken far longer than the time interval alleged by the state. 2, that there were multiple weapons used against Kaylee and Zaina, and Ethan appeared to have been attacked at the same time. Turvey, report page 20. So on his report, he's done a whole big report here on how he thinks things went down. Though his other expert, Rachel Orr, Rachel Orr is another expert for the defendant also submitted evidence that he suffers from developmental coordination disorder, DCD, which has resulted in defects in fine motor dexterity and visual motor function. Well, that's funny because he was in kickboxing and boxing and this and that and, doing crime scene stuff in his schooling and all this, and he had no problems with it. He has no problems driving. He has no problems vacuuming and cleaning up his apartment and crap and all these other things that he does. He has no problem with his fine motor dexterity or visual motor function. How can he drive? How can he obtain a license if he has those problems, right? But, she's trying. You got to give her E for effort. His attorneys have argued in other motions that these defects render it not possible for Mr. Kohberger to have acted with the speed and coordination required to commit the crimes in the time frame alleged by the state. But how quick do you think a boxer has to be? And he was a boxer. However, this has not been disclosed as an opinion of any of the defendant's experts, which means no expert on the defense side will agree that it was impossible for him to do so. But they're trying to claim that, and yet they don't have an expert that says that's true. So that kind of blows that out of the water. In rebuttal, the state disclosed Detective Darren Gilbertson, a lead investigator for ISP in this case. The disclosure indicates he will testify that he and other investigators conducted time runs at 1122 King Road to gain an understanding of the approximate time needed to have carried out the homicides. A report of the timed runs is attached to his disclosure. It was performed to determine if one person could carry out the homicides. His opinion will be that, depending on the suspect's pace and route, he could have carried out the crimes in approximately 2 to 4 minutes. Hang on a sec, you guys. Sorry. Defendant argues Detective Gilbert's testimony should be excluded because 1, the state has failed to disclose how Detective Gilbert is an expert in timed runs. 2, the relevance is minimal. It's not minimal. It's highly relevant. 3, important data, recordings, photographs, and notes of the experience were not disclosed. And 4, his opinion carries a risk of juror confusion and prejudice. On the prejudice issue, defendant claims that Detective Gilbertson was already familiar with the house when he did the experiment, and additionally, the house had been vacated. The defendant also notes that the house has been torn down, so he is not able to conduct his own tests. They pushed for that house to be demolished, and now they're trying to use the house not being there as a weapon in their defense. What do you guys think about that? Did you see that coming? I seen it coming. I seen this coming. The defendant also notes the house has been torn down, so he is not able to conduct his own tests. You guys knew it was going to be torn down because you pushed for it to be torn down. You did not want that house standing so the jury could walk through it. It goes on to say, whether Detective Gilbert's opinions are relevant will depend on what Mr. Turvey and Dr. Orr opine at trial. So Detective Gilbert is going to come back with rebuttal if they have Mr. Turvey, which is a defense witness, and Dr. Orr, who is a defense witness. Depending on what they say at the trial, that's going to depend on what if Detective Gilbertson uses this information that he gained. Well, Dr. Turvey does not specifically state in his report that one assailant could not have accomplished the murders in the short time frame alleged by the state. He infers as much through his opinion, and that there was evidence of a cleanup efforts at the crime scene. So you can't say that your expert says it can't be done when it's not in his report, and that's not what he's saying. He's not inferring anything. There's nothing that he said in that report that states that Bryan couldn't have done it, right? But he did state that there was evidence of a cleanup efforts at the crime scene, which would have taken a significantly longer period of time. Well, if the murders could have been committed within 4 to 5 minutes, and he was in there for 17 minutes, there's time there in that time frame that he could have used to try and do that if there was an attempted cleanup, as far as I'm concerned. Hey, Summer Dawn. Exactly, Carol. Further, while Dr. Orr's report does not opine as to what defects in fine motor dexterity and visual motor function defendant suffers from, to the extent she testified to these defects at trial, it may render Dr. Gilbertson's opinions relevant to rebut any inference that the defendant could not have single-handedly committed the crimes in less than 15 minutes. Okay? So if they're saying he could have done it in 5, there was 10 minutes that he could have used to do a cleanup, and if that was even because we don't even know if this is true or not. This is what the defense is saying, right? Summer Dawn, thank you for gifting 5 memberships. If you got a membership from Summer Dawn, please give her a big thanks. We've got Alicia, Nana. Nana's going to be happy she got one. Old McMary's Journal, Rose, and Deborah. Please say thank you to Summer Dawn. Thank you, Summer Dawn, for gifting 5 memberships. I appreciate you. And welcome to everybody to memberships. Okay, so the footnote says the court has indicated in a separate order that there is no foundation at this point for the defendant's assertion that his defects in fine motor dexterity and visual motor function rendered it difficult or impossible for him to commit the crimes. Okay, so we are going to look at that. That's in the neuropsychological and psychiatric evidence. We've got that document right here that we will be going over. Okay, so I just wanted to let you know that footnote, we do have that coming up. Further, given Detective Gilbert's state role as a lead detective for ISP in the investigation, that's Idaho State Police. If you guys aren't familiar with ISP, Idaho State Police, in their investigation, he is well qualified to offer his opinion on suspected movement throughout a crime scene. In addition, there does not appear to be a disclosure violation due to the lack of underlying data. It was a simple experiment consisting of timing Detective Gilbertson moving through the house at a slower speed and a faster speed. His routes were described as well as his pauses to simulate the number of stab wounds each autopsy showed. It does not appear that there are any photographs or recording or any other data not already described herein. As for the defendant's IRE 403 concerns, they are baseless. It's like, oops, there's a slap again on Anne's wrist. The state represents that there were no structural changes to the house when Detective Gilbertson performed his experience. The state further notes that the defendant stipulated to the house being torn down after Detective Gilbertson's report was disclosed. So they knew that Detective Gilbertson done this and that this was going to be used at trial. They could have went in and done their own testing because this was disclosed to them before they stipulated to the house being torn down. Thus, any concern of prejudice in this regard is his own doing. So, if you think you're being prejudiced by this, that's your own doing because you knew of this little thing that Detective Gilbertson did, doing a walkthrough and seeing if there was enough time and all that. You knew he did it. You had the report. You could have done one of your own and chose not to. So, if it's going to prejudice you now, that's your own doing. Defendant cites no basis for jury confusion. Consequently, Detective Gilbertson's disclosed testimony will not be excluded or limited. So that is a big hit to the defense because they have nothing to fight that, because they did nothing on their own to show something different before that house was torn down. Right? They could have gone and done this themselves, and they chose not to. And I do feel like this is going to be very eye-opening for the jury because a lot of people are saying there's not enough time for him to do that. The house looks huge when you look at it from the outside, but it's really not. Okay. Idaho State Police Forensic Lab Scientists. The state disclosed several forensic scientists from the ISP Forensics Lab to testify as experts in this case. The initial disclosure for each scientist describes the subject matter the expert will discuss, including the particular evidence and testing performed. So I'm not going to go through all of this. as to what they did, we've already gone through that, and it was fought about on the 9th. But I'll read the judge's decision. After the defendant moved to compel more complete disclosures, the court advised the state to supplement accordingly. On March 3rd, 2025, the state did so largely by expounding upon the general subject matter of the experts' respective work. They did not add any new opinions. The defendant now moves to limit the scientist's testimony in the state case in chief to their lab reports. This limitation is not necessary. If the scientists testify to something that is not in the been disclosed or did the disclosure lab reports, defendant can object at trial. There is no basis to prospectively limit their testimony now. So just because, Anne, you didn't look through all the supplementary reports and everything that you demanded, too bad for you. And I can see, let's see, mark my words, you guys. Remember, I'm saying this. I think that Anne is going to try and object to a lot of their testimony, saying, that was never disclosed. That was never disclosed. And the prosecution is going to go, yes, it was. Here it is right here. It was disclosed to you. Like if Anne would have taken more time working on this case than taking on another death penalty case when she couldn't even keep up with the information on this one, and the judge called her out on that in court. I told you guys about that months ago, that she had taken on another death penalty case. It's like you're complaining that you can't get through all the evidence on your first case. Why would you take a second one on? So you can use that to try and put off this trial yet again? That's your own doing. You can't fault the court or fault the prosecution for something that you and you alone did. Right? If it looks like a duck and it quacks like a duck, it's a duck. You should never have taken on that second death penalty case. And if you would have spent all your time working on the one that you were supposed to be working on, this one, you'd be ready. It's not anybody else's fault but your own. Gary Dawson. Dr. Gary Dawson was disclosed in rebuttal by the state to testify to the degree of impairment of the victims, particularly Madison Mogen at the time of the homicide. So this is interesting, you guys. I feel, because of what's being said here, that Madison had the most extreme levels of intoxication, okay? And this is why. Because Gary Dawson was disclosed in rebuttal by the state to testify to the degree of impairment of the victims, particularly, and they're pointing out Madison at the time of the homicide. His expert report attached to his disclosure opines that Madison Mogen would have been markedly intoxicated from the effects of alcohol around the time of her death. She would not have had the ability to mount a meaningful response to a sudden threat to her person. Dawson, he further states that while he has limited his review to Madison Mogen, the same general principles apply to the other victims. So I feel like he pointed out Madison because I feel like she's going to be the one that had the highest levels of intoxicating things in her system. And she looked like she was the tiniest of them all, right? The tinier you are, the more intoxicated you will get. Like a larger person can withhold more alcohol than smaller people, right? Anyway, I don't want to get into all that. The defendant seeks to strike his testimony on grounds that it's improper rebuttal. He contends that none of his experts have challenged her ability to fight back or otherwise contested her toxicology levels. The state responds that the opinion rebuts defense expert Brent Turvey's opinion that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, the state argues that evidence Ms. Mogen was unable to effectively fight back supports its position that one assailant could have completed the homicides in a short time frame. I'm just scouring this as we go. Okay. So they're talking about rebuttal evidence. Mr. Jervy, that's for the defense, right? He's a defense expert, has opined in his report that 2 assailants were involved in the homicide, particularly because he believes multiple weapons were used against Kaylee Goncalves. That's interesting. Inferred in this opinion is that one person would not have had the time or ability to use multiple weapons in the time frame alleged when faced with 2 victims. If Miss Mogan was intoxicated to the point of being unable to fight back, however, it would be possible for one suspect to incapacitate her and then use multiple weapons in attacking Mrs. Goncalves. However, whether Dr. Dawson's opinion is relevant depends on how Mr. Jervy's testimony unfolds at trial. Consequently, he disclosed rebuttal opinion will not be excluded or limited. So you want to bring it, the state can rebut it, and the state can have an expert to rebut that. Okay, Lawrence Mowry, Jeffrey Tanzola, and Neil Uhrig. Detective Lawrence Mowry, Agent Jeffrey Tanzola, and Detective Neil Uhrig are forensic detectives who were involved in the investigation in this case. Detective Mowry was an expert in the field of digital forensics. Again, you guys, I am going through this slowly, so if you do want to read all the data, you can go back, pause later, and read it all. So Detective Mowry, expert in the field of digital forensics. Jeff Tanzola is a special agent with the FBI who extracted, processed, and archived the contents of 7 identified digital devices belonging to the defendant. 7 digital devices. So you got a cell phone, a laptop, an iPad maybe. What's the other 4 digital devices he may have? A camera maybe? What do you guys think? Nana says, I definitely have a love-hate relationship with autocorrect. Me too. What do you guys think that 7 digital devices belonging to the defendant? A cell phone, a laptop, a computer, like a desktop, maybe an iPad, maybe a camera, a Ring camera or something? That would still leave 2 more. Like, do you have extra phones? He disclosed to discuss in the state's case in chief extraction, imaging, examination, and processing. Okay. Neil Uhrig is a forensic examiner and detective sergeant for the Post Falls Police, who extracted, processed, and archived the contents of computers belonging to the victims and 2 other roommates of 1122 King Road. So the judges decided there is no basis to exclude or limit the detective's disclosed testimony. A recorder? Yeah, maybe. Maybe, Nana. It is clear they will be testifying to the facts of their investigation, not providing traditional expert opinions. There is no need, therefore, for detectives to identify specifically what the devices and data depict. The factual is in nature, and the defendant has been provided with all the material the detectives reviewed. So it's coming in. Rob Hill. Rob Hill is a special agent with the FBI who reviewed surveillance footage from the hours before and after the homicides occurred, depicting what law enforcement believes is suspect vehicle 1. Agent Hill was disclosed to rebut opinions by defense expert Stephen Becker. So defense expert Stephen Becker has opinions. And he says that it was not possible to ascertain from the surveillance videos whether a front license plate was missing from the vehicle. So that's what the defense expert's saying. Like, you can't see it. You can't tell if there's a front license plate or not. Agent Hill's rebuttal references the full summary of video depicting suspect vehicle 1, which has been disclosed to the defendant, as a basis for his opinion that suspect vehicle 1 did not have a front plate. He then lists the specific camera locations and timestamps that he contends show a clear view of a missing front plate. Now, one of those is going to be the camera on the house beside the 1122 King Road house that was pointing out towards that corner. It's going to come from there, I guarantee you. That's going to be one of them. Thus, the court will not limit his testimony in this regard. So, Special Agent Rob Hill will be able to testify and show those videos. So that's the end of this one, you guys. Jack Osborne says, camera, GPS, 2C's laptops, phone, Uni computer, Firefox TV. Yeah, I don't know. Could very well be. Did he have Firefox on his TV where he'd watch YouTube or news or whatever? Could he, I know the computer, the desktop computer, the laptop, the phone. I forget. So I don't want to say laptop because I forget if they said it. I believe he had a school laptop. So, there could be other things at his office too, like another computer, another laptop, that kind of thing. But that could very well be, Jack. So thank you for that. Kate Bell says maybe Alexa's too. And Nana says a recorder, right? Okay. This one, so this last one was 14 pages. This one is 15. We're going to scroll through this. I'm not going to, I don't know how much of this that I have highlighted. Yeah, I haven't highlighted much of this because this is a lot of behind the scenes things that we already heard about on April 9th, but he's put it in the order too. But I will scroll through it slowly so you guys can go back and read it all later if you so wish. So this is the motion in limine, defendant's motion regarding Rylene Nolan and touch and contact DNA. Defendant moves in limine to exclude the testimony of Rylene Nolan, the lab manager with the Idaho State Police Forensic Services Laboratory, who was disclosed by the state to testify about touch DNA and the transfer of DNA generally, and more specifically, that the DNA located on the knife sheath was more likely the result of a direct transfer. Defendant argues that Ms. Nolan's testimony, as well as any other testimony referencing the terms touch or contact DNA and or purporting to be an opinion about the means or mechanism of how the DNA ended up on the knife sheath, is irrelevant or impermissible under IRE 403 and fails to satisfy our IRE 703. The oral argument on the motion was held on April 9th, 2025. After which the court took the matter under advisement. That's why I'm not going to go through a lot of this, you guys, because it's just reiterating what was already said in court that day. However, the court requests that the parties instruct their witnesses to avoid the use of the terms touch DNA, contact DNA, and trace DNA. So it's like, don't overly use it. You can explain what each is, but don't overly use it, is what I'm getting from this. Whoops. Sorry, I'll go a little slower because there are going to be people that want to read all this. Okay, Mitch says more than one phone. Analysts. The defendant's argument is threefold. First, he seeks to exclude any testimony by Ms. Nolan regarding when and how DNA was found on the knife sheath and how it was transferred there, arguing it conflicts with the current consensus with the forensic science community. It is outside her expertise and is speculative. Second, he argues generally that the use of terms touch and contact DNA should be prohibited at trial as misleading, confusing, and unfairly prejudicial. Finally, he argues that Ms. Nolan's rebuttal opinions may be stricken as improper rebuttal. Each will be addressed in turn. So, regarding Ms. Nolan is sufficiently qualified. So he is going to allow her to establish what each means and stuff like that, I'm assuming here. Let's scroll down. So they tried to get her stuff thrown out, and it's not going to be thrown out. And like a lot of this, you guys, we've already heard being said in court. So here's the summary of his decision regarding her. In summary, given the liberal standards for qualifying a witness, Ms. Nolan's experience and training in the area of forensic analysis of DNA generally, the current divide in the forensics community regarding whether lab analysts are qualified to testify to DNA transfer, and the lack of jurisprudence on the matter, the court declines to find that Ms. Nolan lacks the qualifications necessary to provide an opinion on DNA transfer in this case. Defendants challenges to her qualifications simply the weight to be afforded to her testimony. So she is going to be able to testify, and her testimony will assist the trier of fact. Having determined Ms. Nolan is qualified as an expert, the court must determine whether her testimony will assist the trier of fact in understanding the evidence. And down here it says, like I said, you guys can pause later and read all this if you so wish. Indeed, Ms. Nolan is offering the very opinion that the Glass court found lacking, i.e., the correlation between the amount of DNA deposited and the likelihood it was transferred by direct or indirect contact. This will aid the jury in understanding the evidence. Consequently, her opinions will not be excluded. Okay, so B, he denied it in part and granted this in part. But what he is saying here is misleading DNA labels are to be avoided. Defendant next argues that the term touch or contact DNA should be excluded under IRE 403 because it could mislead the jury into inferring that the depositor of DNA actually touched the object on which it was found. The state only addresses the term touch DNA and argues it should be allowed because it's a common term within the field. Further, the state points out that it will be clear to the jury from Ms. Nolan's testimony that touch DNA is a term used only to distinguish that type of DNA from other kinds of DNA. Touch DNA is a shorthand reference to the I'm not going to say it, or skin cells that may be left behind on an object when it is touched or comes into contact with the skin. Given the ubiquitousness, there we go. See that? See how I did that? The term touch DNA in not only the forensic DNA field, but in the legal and scientific field as well. The court is unwilling to prohibit the term. So they can use it. They can use it. There is too great a risk that a witness or counsel will inadvertently refer to the term out of habit, potentially giving rise to a motion for a mistrial for violation of a court order. So the judge is basically saying, I'm not going to prohibit it because if it happens to slip out or somebody says it, because this is a common term used in the forensics society, right? In the scientific field. So what the defense is trying to do is have them not being able to allow to say that, and the court saying, yeah, well, it's commonly used in the scientific field, and if it happens to slip out, then you can say mistrial. So he's not going to abolish it. So like he says right here, there is too great a risk that a witness or counsel will inadvertently refer to the term out of habit, potentially giving rise to a motion for a mistrial or violation of a court order. Moreover, the court is not concerned that the jury will be misled, given that both parties have DNA experts who can easily disabuse the jury of any mistake in correlating touch DNA with actual touching. That said, the court asks that the counsel try to avoid the use of the term as much as possible so that any potential confusion can be bypassed. To this end, the parties are instructed to submit a manually agreeable instruction to provide to the jury in case the terms are inadvertently used. If a witness uses the term, opposing counsel can examine the witness about the broader meaning of the term within the forensic community, and the instruction may be given at that time. Yes, so this is good. So they can use it. They would like them to use it as less as possible so they don't confuse the jury. So, okay. Ms. Nolan's rebuttal opinions are proper. Defendant's final argument is that Ms. Nolan's anticipated rebuttal testimony is improper because it does not respond to any opinion by the defendant's own expert regarding DNA transfer. The court does not agree. Rebuttal evidence is evidence that explains, repels, counteracts, or disproves evidence which has been introduced by or on behalf of the adverse party. So, don't call a witness as an expert and then not expect the other side to have a rebuttal witness. That's how it works, Anne, and you know this. Given Dr. Ballard's anticipated testimony, Mrs. Nolan's rebuttal is proper. So whatever this Dr. Ballard that they have, the anticipated testimony that he's going to give is going to be much like Ray. You know what I mean? Miss Nolan's rebuttal is proper. She will discuss the process of primary and secondary transfer, the variables affecting a transfer, and persistence of it, and why she is of the opinion that the DNA on the knife sheath was more likely the result of a direct transfer, which means directly from Bryan Kohberger to that button. Of course, if Dr. Ballard limits her testimony on the stand, the court can reconsider the scope of Miss Nolan's rebuttal. However, based on Dr. Ballard's report, Miss Nolan's anticipated rebuttal is appropriate. So it's like they want to bring in a witness that says something, but then limit how Nolan can respond to that, to rebut it, and to prove it wrong. And you can't use touch, and you can't use this, and you can't use that, and you can't because that'll blow our expert out of the water. Basically, that's just my opinion. So, based on the foregoing defendant's motion in limine, Ryland Nolan, in reference to touch and contact DNA, is granted in part and denied in part. So the denied in part is just like try not to use it all the time. Like try to limit it, right? Yeah. Haha. I love that, Carol. Like saying don't think of a giraffe for the next hour. Now we're all going to be thinking of a giraffe for the next hour. Thank you, Carol. Okay, ID on bushy eyebrows. Okay, so this was another big, huge one that the defense needed tossed out. This is huge. Witness identification by bushy eyebrows. If you guys don't remember, they showed that picture. Let me see if I got it here. Whoops. Let me move that over here. Hang on a sec, you guys. I'm trying to find that picture. Did I put it in here? Hang on. Where's that picture? Oh, there it is. Remember this picture? Remember this picture, you guys? This photo, and I know I don't got a very good copy of it here. This photo, and it looks like he has a bruise here and possibly a Band-Aid on this finger over here. It's just my opinion. You notice the shower curtain's gone. He would have had to get rid of that. Yes, this was taken a couple hours. I think they said like 10:30 in the morning. So say 4 or 5 hours after the murders were committed, like showered up and everything and ready to go, right? Also, if you guys want to give this picture a little more context, don't forget, they have him going back to that crime scene at 9:30 in the morning. Okay? They have him going back and leaving again and going back to his apartment. This picture was taken at 10:30. So is this the thumbs up? Hey, no cops, no nothing there. It's like 10:30 because this picture here they said was taken around 10:30 in the morning. So this is once he's gone back in the morning at 9:30 and went past the crime scene and seen nothing happening, no cops, no nothing. This leads me to believe that he didn't know that Bethany was there. He didn't see Bethany, and he didn't know about Bethany or Dylan. Sorry, he didn't see Dylan. So he's thinking to me at this point, what I'm getting from this picture is nobody knows. Nobody knows. I got them all. I don't think he realized at this point that um, Dylan and Bethany were there and still and that Dylan seen him. I don't think he knew that. Right? Right? So being that this picture was taken that very morning, hours after the murder, look at his eyebrows. Look at those eyebrows. Now he's got them all cut back and trimmed up nice, but look at these eyebrows, like you idiot. And the shower curtain looks to be gone. Okay, so we'll keep that. Okay, so I showed that picture because of what's got coming up right here. Order on defendant's motion in limine. So this is another defendant motion. Witness identification by bushy eyebrows. Dylan, a roommate of the victims in this case, was the sole eyewitness to the intruder believed to have carried out the homicides at 1122 King Road. Do earplugs carry any kind of electronic footprint? I don't know. Oh, I don't know. They would have to connect via Bluetooth, right? Kate Bell's a straight up creeper, yeah. During her interviews with law enforcement and the preliminary hearing in this matter, Dylan described the intruder as having bushy eyebrows. Defendant moves in limine to exclude any evidence at trial referencing bushy eyebrows, arguing Dylan's description is unreliable and therefore irrelevant and or barred by IRE 403. The state responds that DM's description is based on her personal knowledge, is relevant, and there is no basis for exclusion. Oral argument on the motion was held on April 9th, after which the court took the matter under advisement. The court concludes that DM's description of the suspect eyebrows is admissible. So we're not going to go through all 10 pages. I might have highlighted some things, but I will scroll through in case you guys do want to read it all. But this is just basically going to go over what we heard April 9th. So let me scroll through the document for those who are going to want to read it later. Almost done. So here's the order. Based on the foregoing, the defendant's motion in limine, witness identification by bushy eyebrows is denied. So that information and Dylan's description is coming in. Okay, text messages. Let me take a drink of my coffee here. Order on state's motion in limine, read text messages and 911 call. Dylan and Bethany are the two surviving roommates of 1122 King Road. At the time of the homicides, and the only reason you guys I'm saying their names is because everybody knows. At the time the homicides were believed to have occurred, Dylan saw a masked intruder in the house and began calling and texting the other roommates, including Bethany. Approximately 8 hours after Dylan saw the intruder, Bethany called 911 from her phone. Before the court is the state's motion to allow the text messages by DM and BF testimony about their conversations with each other about what DM saw in the 911 call. The state argues these communications are either not hearsay or qualify under one or more exception to the hearsay rule. It also asks that a transcript of the 911 call be provided to the jury to view while listening to the audio. The defendant is challenging several of the communications and objects to the use of a transcript. So I'm going to give an overall because we have already gone through the text messages, both sets, because 2 sets came out. We went through both of them. We went over the 911 call. But what I'm going to do is I'm going to give you an overall, and then we're going to go to the attachment. Okay? So basically, the prosecution is saying, oh, hell no. Everything in those text messages is relevant because it gives you what they were thinking and what they were doing at the time, during and after the red drums, right? What they did in the morning when they got up, who they contacted, what they were saying back and forth. And then the 911 call is absolutely evidence that the jury should hear, right? You hear the horrific little time frame there where they see Xana, okay? And they know there's something terribly wrong. So that's basically, I am going to scroll through this so you can read it, and then we are going to go through the attachment on this because it points out the things that the judge is not going to allow. Everything else is allowed except for the things that I'm going to point out in the attachment. So it goes through it all, the facts. It goes through all the messages and everything again. We've already gone through all these. Here's the 911 call. Okay, so the analyst. The state seeks to admit Dylan and Bethany's phone records from November 13th, including call records and text messages, as well as elicit testimony from Dylan and Bethany regarding their communications with each other on November 13th, 2022. That they testified to before the grand jury. The state also seeks to admit the 911 call and the official transcript thereof. The state argues these records and communication are not hearsay, or they are expected from hearsay as excited utterances or present sense impressions, which is like present sense of like, oh my God, look at Xana, like when they find her and that, right? The exception, present sense expressions. So then the defense objects, arguing that apart from H.J. Hunter, I think, statement to 911 that Xana was not breathing, the exceptions do not apply to the hearsay statements. The court finds the bulk of the statements are likely admissible, with 3 exceptions of the statements during the 911 call. So let's go and see. So he's allowing everything in except for these 3. So I'm going to still scroll through this. So if you want to read through it, text messages and verbal conversations between DM and BF are likely admissible. The state must establish foundation requirements for such proffered statements at the time of trial. The text, we're going to get to the attachment, you guys. Don't worry. DM texts an Uber driver at 2:10 to inquire if he's driving. Text messages between 4:22 and 4:26. Consequently, the court concludes that the assertive text messages within this 4-minute period are likely admissible at present sense impressions and or excited utterances, assuming the requisite foundation is provided at time of trial. Dylan's text to the victims, we've already gone through all these. Again, the court does not find these texts to be assertions. They are not inquiries, not declarative statements. even if they were assertions. However, if the state intends to admit the statements to establish a timeline of events, they are not hearsay because they are not offered to establish their truth. Therefore, they are not barred. Jack says, with the correct light filter and magnification, there is visible blisters on the left thumb, but BK writes right-handed. Yeah. I don't know how to do all that stuff, though, Jack. Then he says, BK looks happier than his graduation day photo, right? Good morning, Norma. Okay, so DM's calls and texts to and from others. The state contends that the text between DM and her dad, the text from JM, I think that's Julie, and the vandal alert are not hearsay because they will be offered simply to show a timeline for the morning and early afternoon. In addition, the state notes that the phone call from DM to EA is not a statement and therefore not hearsay. The court agrees and will allow the evidence for purposes of a timeline if the requisite foundation is laid. Verbal communications between BF and DM, that's going to come in. Thus, to the extent they testify to oral conversations they had after they woke up the next morning, the court will reserve ruling and consider any hearsay objections at the time. The footnote here says the state does not address the content of that call. However, the court finds it likely qualifies as present sense impression. Dylan testified that she asked EA to come over and check the house because she was scared. She is describing her fear at the time she is experiencing it. Beyond that, the specifics of what was said regarding what DM saw hours prior will have to be analyzed at the time of trial. The 911 call. The state contends that the entirety of the 911 call should be admitted because the statements therein are not herein are either non-hearsay or not admitted for the truth of the matter asserted, or they are expected from the hearsay rule as a present sense impressions or excited utterances. Defendant generally objects to its omission, but takes particular issue with 3 statements within the call. The court finds defendant's objections to these specific 3 statements well placed, but will allow the balance of the call because the statements are either not assertions, not admitted for their truth, or they are expected from the rule as set forth in Exhibit B. Okay, so let's go to that exhibit. Like I said, you guys can go through and read this. I was going to read through all this because I didn't think the attachment was here, but it is. The judge is just explaining more as to why they can't be entered in. You're going to see this. Don't worry. This is just explaining each statement and how it came to be. And the judge is also going to allow a transcript of the 911 call for demonstrative evidence. But they will not be able to take that into the jury room with them. Okay, so here we go. Here's the schedule. So all of these text messages between them from the time like 2:10 a.m. when Dylan calls the Uber, 2:13 Uber driver DM, 2:53 Madison Mogan calls boyfriend, 3:51 DM creates a new contact in her phone. This is before the perpetrator enters the house. Okay. 4:19 Bethany calls DM for 23 seconds. 4:20 DM calls Azana. DM calls Kaylee. All these things that we seen in the text messages between the two, they're either not hearsay or not an assertion and or not offered for the truth of the matter asserted, or they're either present tense impressions or excited utterances. All of these, okay? So all of these are going to be admitted. Like everyone, like phone's going to die, F, come to my room, run down here, all of these. So all of these are going to be admitted. All of them are going to be admitted so far. Now, this is the 911 call. This is where things change. Okay, so when I believe it's Julie, when the female speaker, one of the roommates is passed out and she was drunk last night and she's not waking up. That has to be bleeped out. It's hearsay. It does not qualify it as present sense impression. So that one's got to be bleeped out of the 911 call. The next one, another female speaker. Oh, and they saw some man in their house last night. That's hearsay. Because she's saying something that was told to her by somebody else. She wasn't there to hear this herself, right? The same as this. She wasn't there to see any of the roommates drunk and passed out and blah, 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 right? So, and there's one more here. Dylan, I don't really know, but pretty much at 4 a.m., where she goes into, she's going to try and say what happened at 4 a.m. The judge has said it's hearsay. It does not qualify as excited utterance because she's trying to repeat something that had happened earlier. So it wasn't happening at the time of the 911 call. So it's not going to be able to be admitted in the 911 call, but it is admitted back here. Back here, right? So it's already admitted as excited utterances in the text messages. I'm freaking out. No, it's like a ski mask, where she says that she sees this guy. Yeah, dude, what the F? Xander was wearing all black. I'm freaked out. No, it's like a ski mask almost. Actually, like he had something over his head and a little around his mouth. Not kidding. So it's already admitted up there what happened in, so the jury is going to see that evidence, right? So that not being allowed down here, where is it? Down here really doesn't concern me. This too, and this, it's nothing really. Like, I'm just glad that this is all that the judge redacted. So all of this is going to be admitted. So this is where the 911 operator is asking HJ, is she breathing? And he says, no. And once he sees Xana and finds her the way that he found her, that's when he hands the phone back to Dylan, because he can't even talk anymore after what he just seen, right? Okay, so that's when they hang up. So that one's that. So I think the things that have to be redacted in the 911 call, I don't think it's a big issue at all. My throat is getting so dry, you guys. So this here, you guys, I'll scroll through it, but this is just memorializing the orders that he's already made. Okay. From April 9th. Standards. Evidence is relevant if it has any tendency to make existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Okay? So analysts, inflammatory evidence. The judge denied this because he said at this point the defendant has not identified what specific evidence he wants kept out or otherwise defined exceptionally inflammatory. So he finds it unnecessary to make an order on that. Defendant's use of the terms murder. Defendant seeks to prohibit the use of the words murder, murderer, murdered, murder weapon, and similar forms of the word as applied to the defendant. Again, the defendant seeks an order requiring the state to abide by the evidentiary rules, particularly the prohibition against argument outside of closing. This is unnecessary. And he says that, they can, they know the rules that they've got to follow, and he believes that they will follow it. Defendant's motion in limine again, use of the term psychopath or sociopath. Defendant moves to exclude any reference to the term psychopath or sociopath at trial, arguing it is unfairly prejudicial under IRE 403 and improper opinion testimony under IRE 702. The state does not intend to use these terms at trial. Indeed, the terms are irrelevant given the lack of evidence. Defendant has been diagnosed with a personality disorder or similar mental illness. So it's granted because it's mute anyway, because the state isn't planning on using these words to describe Bryan. But if, however, the state believes the door has been opened to allow the use of such terms, it shall raise the matter in advance outside of the presence of the jury. So if the defense opens that door, then this order will be rescinded. Okay? Okay, improper death penalty comments. The state moves under IRE 401 and 403 to preclude defense counsel from making what calls improper comments about the death penalty, specifically that the state is attempting to kill the defendant, with which the defendant counsel has stated in past hearings. So the defendant stipulates to using phrases that comport with existing language in statute and jury instruction. So they're saying, we're not going to do that in front of the jury, so this is mute. So the court says, I don't got to make an order. You guys know what the existing language in statute and jury instructions are. That's what you must use. So he didn't make an order on that. He's saying it's unnecessary. Unnoticed 404B evidence. Defendant moves in limine to exclude any IRE 404B evidence that has not already been noticed by the state, which at this point is only defendant's pre-homicide traffic stop. Defendant notes that the state intends to present evidence of the defendant's graduate paper regarding how to conduct a crime scene investigation and his Amazon purchases records, both of which defendant contends are subject to IRE 404B. Defendant appears to misapprehend the scope of the IRE 404B rule. If the evidence does not bear upon the defendant's character, it is not subject to 404B. So the motion's denied. So he's going to be able to use the traffic stop and the paper that Bryan Kohberger wrote. The state's going to be able to use that. So the defendant's improper expert testimony, Middleman. Defendant's motion in limine to exclude IgG. We go again with this damn IgG. State's MIL, investigative genetic genealogy. Both parties move to exclude, so this is stipulated. Both parties move to exclude evidence of law enforcement's investigative genetic genealogy, I'm just going to say IgG, testing in this case, but for entirely different reasons. Given the parties' agreement to not present any IgG evidence, those reasons not need be discussed given the bottom line agreement, and the court grants the motions. The state has indicated it will present evidence through Detective Brent Payne that the defendant's name was revealed to law enforcement through a tip. To avoid issues at trial, the court advises the parties to arrive at a mutually agreeable narrative about how the tip came about. The parties are also directed to jointly craft a jury instruction advising the jurors to not concern themselves with the source or nature of the tip. Conditions as aggravator. Defendant moves to prevent the state from using the defendant's diagnosis of autism spectrum ASD and its characteristics of his ASD as an aggravating factor at the penalty phase. The state's response: it has no plans to use such evidence as an aggravating factor, but it will argue against the rebut defendant's diagnosis to the extent he replies upon it as a mitigating factor. So it's like, if you're going to use it as a mitigating factor, we're going to use it. The court foresees an issue potentially arising at trial whereby the state makes reference to an action taken by the defendant that the defendant contends is a symptom of his ASD. That evidence is not currently before the court. Thus, at this point, the court will preclude the state from arguing or presenting evidence of defendant's ASD diagnosis as an aggravator, but it is not in a position to rule on whether any particular evidence must be excluded on grounds that it evidences a symptom of the defendant's ASD. The motion is therefore granted in part only. State's motion in limine, alternative perpetrator evidence. The state seeks an order prohibiting defendant from offering an alternate perpetrator evidence without first making a showing that such evidence is relevant and admissible under IRE 401 and IRE 403. These rules govern the standard of admissibility for alternate perpetrator evidence. Defendant acknowledges his burden under Meister, but argues the state's motion is premature. While the defendant is correct that such offers of proof can be made at trial, this case is not well suited to waiting until the time of trial, trial by ambush, to do so, particularly if the defendant intends to submit multiple offers of proof. After all, the defendant cannot merely show another person could have committed a crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. To avoid undue delay at trial, defendant must present the offers of proof no later than May 14th. So he's got to give this to the prosecution by May 14th. So the matter can be addressed at the pretrial conference. The court will reserve ruling on the motion. So if you're going to try and say that there could have been other perpetrators, you better come with your evidence of such, direct or circumstantial, linking a third or a fourth person, and you better do it by May 14th or it's going to be thrown out. I think they will. But I mean, if it can be shown that they caused it, it's not a mistrial. You can't cause something to happen and then claim foul, right? But if they can prove that the state did something to cause a mistrial, then a mistrial could, I'm not saying it will be, but it could be classified a mistrial. But you can't do something and then claim foul. The WSU officers identified suspect vehicle 1 and reported to Washington PD on 11/29/22. They sat on it and did nothing. Keep that out of the media and court proceedings. I did see it, Jack, in a filing. That's how I found out about it. It has been brought up. When the description of the vehicle was put out to the public, that's when the WSU officer said, hey, we got this guy, Bryan Kohberger, that has a Hyundai Elantra. So I remember that coming out previously. I think that information was given to Moscow police, but they sat on it. No, you can't throw your own case. You can't do something and then claim foul. You know what I mean? Now, that's why they were trying to get all these words that nobody could say in. So if the state or a state witness or something did bring up those words, and that's what the judge did respond to that, he said, look that puts us in a serious position that if somebody slips out the word contact or touch DNA, that it could cause a mistrial. He says, so he's not going to order that. But he's asking them to limit those words as much as possible. So that's why they were trying to get those words an order that they couldn't say certain words. That's why they wanted it in there, so they could use that to try and maybe get a mistrial. Okay, so statistical analyst. Defendant moves in limine. Again, another defendant motion in limine to exclude any misleading comments about the meaning of likelihood ratio for DNA purposes. The state agrees that this type of comparison is inappropriate. So this was something that was brought up at the grand jury. And the way the question was posed or the information was posed was not correct. So they're saying that that part of the grand jury stuff cannot be used. Inconclusive data. Defendant moves to limit expert testimony about the Idaho State Police Forensic Lab statistical analysis of a swab taken from the fingernail clippings of Madison Mogan, item Q13-1. The state indicates it will not offer the results of Q13-1 as inculpatory evidence, which defendant agrees renders this motion moot. So it's denied as moot. Defendant's motion eliminate excluding Amazon click activity evidence at trial. Defendant moves to exclude any evidence of the defendant's Amazon purchase history or click activity on grounds that it's out of context, incomplete, and unfairly prejudicial. Now, this is like a catch-22 because if the state would have put in everybody's clicking history and everything, they would have said, they would have complained about that too, that it was prejudicial because you included all the family's click activity and this and that, and it's all getting mixed and you're confusing the jury. You know what I mean? So they've limited it to certain things that they were looking for, but they're still not happy with that. So they're saying that it's incomplete and unfairly prejudicial. This evidence will be presented by the state through Shane Cox and Michael Douglas, who will testify simply to what the documentary evidence state, all of which was provided to the defendant in discovery. The evidence is highly relevant. A K-bar knife sheath was found laying next to the body of one of the deceased victims, all of whom were stabbed to death. Defendant's DNA was found on the knife sheath. Records from an Amazon account registered to the defendant's name and email show that a purchase of a K-bar knife and sheath was made from the account approximately 8 months prior to the homicides. Click activity on the same account shows that the customer also viewed pages associated with K-bar style knives at that time, and in the week following the purchase, viewed pages associated with the shipping progress of the knife sheath. The product was shipped to Bryan Kohberger at his family address in Pennsylvania. So if they're going to try and say, oh, my sister was going on a camping trip and she ordered it for a camping trip, well, no, because you're the one that did it on your name and it was shipped to Bryan Kohberger. Give me 2 seconds, you guys. Okay, yeah. Okay, sorry about that. Okay, so she was shipped to Bryan Kohberger at his family address in Pennsylvania. After the homicides, activity from the same account showed the user navigated pages related to the deletion of account activity, and a week later viewed pages associated with a K-bar knife and sheath. This evidence establishes a significant connection between the defendant and a K-bar knife and sheath. Let's see what Jack is saying over here. I always love his comments. WCA car park CCTV caught his suspect via one departing that night at 2:42 a.m. and returned early morning 5:40ish. Yes. Okay. In addition, there is no basis under IRE 403 to exclude the evidence, particularly given how probative it is. Defendant argues it's misleading and prejudicial because it paints an incomplete picture of the account activity. Blah, blah, blah. Defendant is free to challenge this evidence through cross-examination and establish through Mr. Howell why more information is needed to reach the conclusions that defendant made the purchases or clicks. However, it is not basis for exclusion. Thus, the motion is denied. It's all coming in, you guys. His Amazon stuff is all coming in. Okay. The state's motion in limine AT&T timing advanced records. The state moves in limine to prohibit the defense from making any reference to the absence of AT&T timing advanced records, TA records, related to the defendant's cell phone. This is big because you remember this Syre who has this garbage science and junk science that he uses that he says his stuff is better than what the FBI and cast and Celebrate and all that, which it's not, because a lot of cases have been overturned because of his junk app or junk thing that they use. Anyway, the state contends it never received such records from AT&T in response to its subpoenas, and therefore any statements by the defendant that the records could have or should have been provided to the defendant should not be allowed, as it mischaracterizes the evidence, will mislead the jury, waste time, and cause delay. This is the same time when we seen on April 9th when the judge lost it and said, making accusations and accusing the prosecution of withholding evidence and stuff like that, that's reason for disbarment. And that's what Cy Ray tried to attack the prosecution and say they were lying and they didn't give us that information and they're not giving us all their methodologies and all this bullshit. Okay? So they don't want the defendant to be able to bring that up in court and say, oh, we didn't get it. They got it for everybody else. Yeah, because they didn't know who he was for a month and a half. And by then, those records didn't exist for him. Idiot. Okay, so here it is here. The homicides occurred on November 13, 2022. The defendant first became a person of interest on December 19, 2022. The two AT&T warrants were issued on December 23rd. Thus, TA records for the defendant that could have been of any relevance had long been discarded by AT&T and no longer existed. So they didn't request them until December 23rd. They only keep them for 7 days. So from November 13th, 7 days. So by the 1st of December, they were gone. Okay, applying these principles here, defendant will be allowed to voir dire special agent balance outside the presence of the jury to ask whether he received defendant's TA records covering the early morning hours of November 13, 2022 and the months prior when defendant was believed to have been in the area of 1122 King Road. However, if agent balance denies having received the TA records, defendant may not explore the matter further, either in voir dire or before the jury. Given the absolute lack of any factual basis supporting his position that the state is hiding them. Ooh, that's like, boom. Given the absolute lack of any factual basis, and he's saying it right here, Cy Ray's stuff is junk science. And it's been ruled that by judges and the legal field many times. Cases have been overturned because his stuff was junk science. Anyway, so the state's motion is granted, right? Let's see what this is. 10. Mr. Ray's affidavit, which forms the basis of the defendant's challenge, is replete with speculation and unfounded and thus highly improper accusations against the state. Further, not once in his affidavit does he address AT&T's 7-day retention period, which fully explains why the state was unable to obtain relevant TA records for the defendant. Let's highlight that. And I gotta save it. Like he absolute lack of any factual basis supporting his position, which means he's Cy Ray and all his garbage science that he uses. The judge basically told him right there, it's junk. It's not believable, and it's junk. And you accusing the state with speculation and unfounded shit, that's like a beware. You better beware, Mr. Ray, because the judge is not happy with you. Okay, admissibility of demonstrative evidence. Here's another good one that we were looking for. Here's Jack again. The SV1, so suspect vehicle 1, has a unique identifier scratch on the left side of the vehicle. The Pullman traffic stop video has been edited as the scratch is visible in one of the video and cut out in the other video for media. Ooh, interesting, Jack. Interesting. See? Jack always brings up either good points or good info. He says the driver's side door just below the windowsill, above the door lock, 5-inch scratch. Ooh, cool. Okay. The state seeks permission to use a not-to-scale 3D model of the 1122 King Road residence as a demonstrative exhibit at trial, contingent on the state laying sufficient foundation to establish a basic accuracy of the model and a demonstration that it will be helpful to explaining the testimony of the presenting witnesses. The state contends the model will aid certain witnesses in describing their testimony. The defendant objects, arguing the state's drawing of the model and other related information was only recently disclosed in discovery in a file defendant describes as massive. Everything, there's tons in this. Would you expect, like a little folder of 2 pages? Defendant claims the data and model cannot reasonably be evaluated by its expert in time. That's your fault. Defendant disputes that the model is relevant, and even if it was, claims it should be excluded under IRE 403 due to the danger it might not be accurate. So what did the judge say? In addition, there is no basis under IRE 403 to exclude the model. So the defendant, as soon as it's good. Okay, so here is his ruling. Moreover, as discussed, Mr. Nodal's concern about the time constraints based on his impression that he'll have to analyze the underlying data to ensure the model's proper scale, dimension, and completeness. Nodal, again, accuracy is not the standard, and Mr. Nodal need only assure himself that the model is not deceptive, and there is sufficient time to do this given the August trial date. That's what I'm saying. They're trying to get the trial moved again. We need more time. To this end, the state is to make the model available to the defendant as soon as it's completed and no later than the pretrial conference. So they got to get this done by May 15th. The motion is granted, so they can use the model of the house, you guys. Yeah, if you have the pictures, Jack, you can send them to my email and I can pull them up. Let me just go turn down my heat, you guys. I'm boiling. Okay, give me 2 minutes, you guys. Jack, if you want to email me those photos, you can. Let me know if you have. Give me a couple minutes, you guys. I got to run pee and I've got to get some cool air in this house because I'm boiling. So give me 2 minutes and I'll be right back. Okay, sorry about that, you guys. I don't know why that furnace was running for so long, but it was running like crazy and I was boiling over here. Okay. Carolette says, Jack, yeah, send to Willow. You're a super sleuth. Yes, Jack, if you want to send them, just let me know that you sent them so I can go and check them. Uh, Jack says, I've only seen it on one video, and next time I noticed the traffic stop video was reduced frame size and scratch was excluded. Maybe they have traffic CCTV with the left side of the vehicle as an identifier. Thank you, sister, for posting them. And those coming in, if you did get a free 30-day membership from Summer Dawn, please make sure you thank her. Okay, so state's motion in limine regarding the alibi. State moves to preclude the defendant from offering any evidence in support of an alibi other than the defendant himself. The basis for the state motion is defendant's failure to comply with the notice requirements governing alibi. And if requested by the state during discovery, the defendant to offer an alibi must file a notice listing the specific place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. The court has discretion to exclude testimony of any undisclosed witness offered as to a defendant's absence from at the scene of the offense. An alibi is a defense based on the physical impossibility of a defendant's guilt by placing the defendant in a location other than the scene of the crime at a relevant time. Hence, in setting forth the notice requirements for an alibi defense, I require the defendant to proffer evidence establishing where the defendant was at the time of the alleged offense. Evidence only counts as alibi evidence if it proves that the defendant could not have been present at the scene of the offense at the time it was committed. At this point, the defendant has only provided notice that he was out driving in the early morning hours of November 13th throughout the area south of Pullman, Washington, and west of Moscow, Idaho. He intends to present testimony by his expert, Cy Ray. Oh, yeah. Well, do it. Do it. Defense, do it, because Cy Ray is going to be ripped apart. He intends to present testimony by his expert, Cy Ray. The judge is already not happy with Cy Ray and has called him out, partially to corroborate his alibi using CSLI data from the defendant's cell phone. However, the alleged offense occurred between approximately 4:07 and 4:20 a.m. At most, Mr. Ray can opine as to where the defendant's cell phone was up until 2:54 a.m., when it was apparently turned off, and approximately 4:48 a.m., when it began reporting again to the network. The defendant has provided no evidence as to his location at the time of the crime. In other words, he has provided no alibi evidence as contemplating by the rules. So the judge has said there are still 4 months until trial begins. If the defendant does unearth alibi evidence, it is his obligation to immediately make the state and the court aware of it. At that point, the court can apply the Juarez standard. Excluding it at this time is premature, and therefore the motion is denied, subject to being re-raised if defendant does not disclose alibi evidence. So, unless he gives the evidence, he can't use it. But right now, the judge isn't willing to make an order on it because there's still 4 months left. However, at this point, defendant has not provided an alibi, partial or otherwise. Okay, the state's 404B notice prior traffic stop. The state moves under IRE 404B for the admission of the defendant's August 21st, 2022 traffic stop in Moscow, Idaho, during which he was stopped for speeding and issued a citation for failing to wear a seatbelt. Specifically, the state seeks to admit the officer's OBV footage, onboard video footage of the traffic stop, as well as a citation, arguing it is relevant to proving defendant's identity, vehicle ownership, and control, address, and phone number. The defendant objects, pointing to Idaho Supreme Court's case law of evidence of prior misconduct is irrelevant. Well, they're not using it for prior misconduct or character. They're using it to identify the person driving that vehicle and that he owned it, and his address and his phone number. So confusingly, the defendant argues his prior traffic stop bears no resemblance to the charged crimes and therefore cannot be relevant to identity. He also argues it's unfairly prejudicial and may confuse the issues. The court finds the evidence is relevant to establish defendant's identity and link him to the charged crimes. Indeed, the citation and onboard video footage, up to the point that the defendant provides his phone number, serve to identify the defendant by name, physical appearance, phone number, and address. The evidence also establishes the defendant as a registered owner and driver of the vehicle, the make and model of which was thought to be used by the killer. Further, the evidence places the defendant in Moscow at night on one of the dates of interest alleged by the state to be relevant to planning the charged crime. All these factors played a role in the investigation of the crime. And what they're saying here is they've got to bleep out his phone number or something. Let's see, 19. Just prior to the defendant providing his phone number, he asked the officer why they needed it. This is after the defendant provided his phone number and he and the officer discuss ancillary matters that in no way bear on the defendant's identity. Thus, this portion of the onboard video shall be redacted. Yeah, I knew there was something about that. Okay. So upon weighing the IRE 403 factors, the only portion of the onboard video footage the court finds troubling is when the defendant requires why the officer needs his phone number. This inquiry could be perceived by jurors to be insolent, given its lack of relevance and potential for prejudice. The inquiry should be redacted. Other than this redaction, there is no basis for further exclusion. Defendant claims of unfair prejudice and jury confusion lack merit. Thus, the motion is granted with the noted redaction. So they can use that footage. They just got to redact about him asking why they need his phone number. Okay, we're getting there, you guys. We've been here almost 2 hours. We're getting there. Okay, the next one. Oh, this one is another 15-pager, you guys. Order on defendant's motion to strike the death penalty. And this is what I mean. They're trying to do everything at this point just to save his life. They know he's done. Okay, so again, I'll scroll through this. There's a lot of crap in here that's already been talked about. So I have highlighted stuff that we will go over. I will scroll through it. So if you guys do want to go back and read it, you can do so and pause the video so you can read it all. So the introduction: having been recently diagnosed with autism spectrum disorder, ASD, by a clinical neuropsychologist retained by his defense team, defendant seeks to strike the death penalty as a sentencing option, arguing it violates his constitutional rights. So it's funny that this only comes out now. Why didn't this come out when he was saying he was seeing this visual snow, right? White snow, visual snow. You know what I mean? Why didn't he mention any of this before? Why is it only coming out now? I believe this is fabricated. I believe his mother helped fabricate this. But anyway, it is what it is. Anybody can meet with a psychiatrist or psychologist or whatever and say, oh yeah, I have, like, you can fake this. It's so easily You can fake this if you need to. You may agree or disagree with me, but I find it very odd that this comes up now. Visual snow thing, nope, that's not a mental health disorder. Nope, nope, nope. This and that, everything they've tried hasn't worked, so now they're going to try this. So, what else is next? You know what I mean? What are they going to try next? Anyway, the judge calls it out. Now, I don't know if it's in this one or the next one because we got one more to go after that. That's this one. I don't know if it's in this one or the next one. I spent 3.5 hours this morning, you guys, well, almost 3.5 hours this morning, going through all these and highlighting the important parts. So give me a round of applause. I'm unsure which motion, I guess that was denied anyhow. The full traffic stop is going to be allowed in. They just got to redact the part about when he questions her about why they need his phone number. Okay, so having been recently diagnosed with okay, we read this. Defendant seeks to strike the death penalty as a sentencing option, arguing it violates his constitutional rights. He contends ASD is the functional equivalent of an intellectual disability, which is categorically recognized as a disqualifying exemption to the death penalty. If you guys want to read through all this, they already talked about this April 9th. So I'm not going to read through it again. I'm losing my voice, as you can tell. Where was he questioning the lady cop rules regarding turn rules? Okay. So if you guys want to read through this, you can. I'm going to read the highlighted parts. Based on her evaluation, Dr. Orr, which is like these people are all for the defense, okay, diagnosed the defendant with autism spectrum disorder level 1 without accompanying intellectual or language impairment. Okay, so according to Dr. Orr, ASD is a complex, heterogeneous neurodevelopmental disorder rooted in brain differences and characterized by social or behavioral features. It causes defects in which affected individuals perceive to react to others and their environment, causing problems in social communication and interactions, repetitive behaviors, and narrow range interests. Well, narrow range of interests, he was fishing. He was going looking at the stars. He was liking driving around. He was in university and taking going for a PhD. He was narrow in range of interest. He was boxing. He adopted a vegan lifestyle. He was teaching. Okay, so narrow range of interest? I don't think so. Repetitive behaviors? I don't know. Problems in social communication and interactions, that has nothing to do with being able to commit a redrum. So how this is relevant, I have no idea. In which affected individuals perceive and react to others and their environment causing problems. I don't see how that has anything to do with somebody, whether they could or could not commit a redrum. Right? Okay. Level 1 is the least severe and requires merely support. Okay, so the severity of ASD is based on 2 criteria. There are 3 levels of severity which correlate to how much support is needed. Level 3, which is the most severe, requires very substantial support. Level 1, which he is the least severe, requires merely support. Like, good boy, you did that well. The fuck out of here. Anyway, in her personal evaluation of the defendant, Dr. Orr observed that the defendant demonstrated some typical social behaviors. Listen to this crap, you guys, okay? So while this doctor is evaluating him, this is what she observes. Think back to every time you see Bryan Kohberger in court, okay? Because I'm telling you, the judge calls it out. In her personal evaluation of the defendant, Dr. Orr observed the defendant demonstrated some typical social behaviors such as fairly consistent, though intense, eye contact, polite demeanor, social conventions, shaking hands upon greeting, so that's all normal. He engaged in conversation and was never overtly inappropriate. However, Dr. Orr also noted social behavior consistent with that reported by others, such as lack of fluidity in his verbal interactions, awkward comments. Okay, so far, none of this has anything to do with whether he could commit a murder or not, or abrupt responses, inconsistent understanding, acknowledgement of humor, and occasional intense gaze. None of that, to me, in my opinion, would stop him from being able to commit a red drum. She noted he had poor receptivity of interaction, including very frequent refocus of conversation back on his own experiences or unusual responses to my sharing. He also noted She also noted his lack of close friends and his poor insight into his role in relationships. Yeah, he didn't have close friends because he threatened to beat them all up if they didn't do what he wanted them to do. Right? We heard that from some of these friends. He was constantly threatening to beat them up. Dr. Orr further observed defects in the defendant's nonverbal communication, noting poor integration of verbalizations and eye contact. Huh? Poor integration of verbalizations and eye contact, but up here you said he had such a fairly consistent, though intense eye contact. Which is it? Limited use of descriptive gestures. What? But up here you say that um, he had typical social behaviors, eye contact, polite demeanor, and social conventions like shaking hands upon greeting. But down here you're saying he has limited use of descriptive gestures. Okay. Restricted range of effect and a typical tone. Like, this is ridiculous. Like, contradicting yourself much right here. Anyway, as to his speech, Dr. Orr observed that defendant was generally clearly articulated and his speech was appropriate in rate and volume. What? Yet up here, you said he had poor reciprocity of interaction, including very frequently focus of conversation back on his own experiences or unusual responses to my sharing. Like, which is it? He was clearly articulate. Okay, I gotta stop. And his speech was appropriate in rate and volume, but overall monotone. His language was generally appropriate, but up here you said it was inappropriate. Oh my God. In content and form with an extensive vocabulary, but or overly formal. But you say he had poor integration or verbalizations. I don't know. To me, this is so contradictory, it's unreal. Says it's highly repetitive with frequent scripted phrases. Smart cookie. Yeah, like, I mean, it's a lot of this is contradictory. He knows what he's doing, right? He needs some kind of diagnosis to get him out of the death penalty. Dr. Orr noted that the defendant often used the phrases objectively speaking, mind you, to be fair, and moral of the story. I use those too, though. And when you're talking in, hang on, I need a drink. Coffee. When you're sitting talking with a doctor or an expert or something like that, you tend to use more different types of language. You know what I mean? Like, okay, yes, I get that. But mind you, this is what I have seen in the course of my studies. But objectively speaking, I could see how your point could make sense. You know what I mean? But to be fair, different circumstances give different results. But the moral of the story is there's still these 4 dead college students. You know what I mean? Yeah, the stops when he was going back to Pennsylvania, they always went on the passenger side, so we didn't get to see. We can't even check those videos to see if there was that scratch there. Anyway, as to the second criterium, Dr. Orr found defendant exhibited all 4 of the behaviors. He engaged in occasional subtle rocking of his upper torso while seated and scripted and repetitive language. When have you subtle rocking? When we have watched him in court for hours, have you ever seen him sitting there rocking back and forth? Never. Okay. Defendant's neuropsychological profile revealed a high average intellect at baseline, and his full scale IQ was 119. Haha, I'm 124, which is in the 90th percentile for his age. Cognitively, defendant showed strong verbal abilities, abstract reasoning, memory, concept formation, and reading skills. What? Strong verbal abilities and memory. Didn't you over here say that he kept forgetting and you had to keep him back on point? Refocus, very frequent refocus the conversation. Like it doesn't, like it's contradictory as far as I'm concerned. You guys can think the way you think, but I'm saying I think this is formulated to, how can I say this nicely? I'm going to give a diagnosis of level 1, and that's iffy, but I'm going to give it to you because you need it. Because this is very contradictory. However, he displayed weakness in executive functioning, such as planning, cognitive flexibility, impulse control, and organizational approach. He tended to perceive information in a piecemeal rather than look at it as a whole picture. Defendant was assigned a level 1 diagnostics, which means diagnostics. Oh my gosh. Like that's the bare minimum that you can give somebody without intellectual impairment, which is the least severe level. Like that's barely. We'll just say it just to keep you happy. You know what I mean? Dr. Eileen Ryan, a board certified psychiatrist retained by the defense team, agreed with Dr. Orr's ASD diagnosis, excuse me, after conducting a comprehensive forensic psychiatric examination of the defendant. Of note, she observed that the defendant is highly intelligent and has a factual understanding of the proceedings against him, the penalty he is possibly facing, pleas, and the roles of the courtroom personnel. Ryan reports. She further noted there was no evidence of a formal thought disorder or thought disorganization. Again, hang on. Again, she further noted there's no evidence of a formal thought disorder or thought disorganization. But up here, didn't she where'd she say that? Disorganized, highly repetitive. We'll get where'd she say disorganized? Poor receptivity of interaction, including very frequent its own experience and unusual responses, also neurological. Where is it? Consistently reported lack of fluidity, verbal intention, awkward comments, inconsistent understanding and acknowledgement of humor. She noted poor receptive interaction, including very frequent. Where did I see that? Cover comments. Inconsistent understanding and acknowledgement of humor, occasional intense gaze, she had poor receptivity of interaction, including very frequent or focused conversation back of his own experiences, or a lack of close friends, poor insight, nonverbal communication, poor integration of verbalizations, eye contact, limited use of descriptive gestures, or restricting age as his speech. Defendant was articulated, his speech was appropriate and rate volume overall, but his language is generally appropriate, content form, extensive vocabulary and form. But she says he's disorganized. Turn off use phrases. But she's saying there's no evidence of formal thought disorder or thought disorganization. There was another video the defense wanted redacted. I haven't seen that one. Male officer, apparently. Okay, so categorical exemption from capital punishment for individuals with ASD is not warranted. So he ain't getting it. Okay? The United States Supreme Court has interpreted the Eighth Amendment to categorically prohibit the execution of three classes of individuals: the intellectually disabled under Aikens, two, individuals who commit murder while before the age of 18, and three, individuals incompetent to be executed under Ford. No court has ever found ASD to be categorically death disqualifying diagnosis. So there you go. There's another. Are you okay? What are they going to come up with next? That's what I'm wondering. What are they going to say he has next? Because now that the court has just found that no court has ever found ASD to be categorically death disqualifying diagnosis, and I said that, I don't know how I said it because my tongue's starting to get twisted here. This is a lot of reading. Anyway, they never found it. So, ASD is not equivalent to an intellectual disability for purposes of death penalty exemption. Let me highlight that. So you guys want to see it when you go back, you will see it. We'll save it. I'm just scrolling through, so if you guys want to go back and read this, you can. Okay, intellectual deficiency, however, is not among the diagnostic criteria for ASD. DSM-5, while individuals with ASD may share some of the same adaptive defects as those with an Aikens qualifying intellectual disability, the essential feature, i.e., intellectual disability, is lacking. So we're scrolling through, so you guys who want to read it all can. Reasoning that FASD cannot be medically equated to an intellectual disability, courts have found that the justifications for exempting individuals with intellectual disabilities from the death penalty do not apply to individuals with FASD. In sum, the defendant has not demonstrated, nor has any court held, that persons with ASD have similar cognitive and behavioral deficiencies that result in an equivalent diminishment of culpability, ability to be deterred, and capacity to assist in their defense as individuals with an intellectual disability. The defendant has not established a national consensus against the execution of individuals with ASD. Good night, Jack. Thank you for all your input. Defendant argues categorically excluding individuals with ASD from capital punishment is consistent with society's prevailing standards of decency. As for legislative enactments, he points to two states, Ohio and Kentucky, which recently enacted legislation barring people with serious mental illness from being sentenced to death. Sorry, you guys. The court says, at best, this evidence demonstrates a growing social sensitivity to mental disorders generally. However, evidence of involving standards of decency must come from legislative and executive actions. Two states protecting individuals with severe mental illness from execution is not a national consensus. Further, these two state statutes only apply to schizophrenia, schizoaffective disorder, bipolar disorder, and delusional disorder, not ASD. So even, sorry, you guys, like I said, allergies are through the roof. It's that time of the year. So even the states that she cites, Ohio and Kentucky, those two states, their statutes only apply to schizophrenia, schizoaffective disorder, bipolar, and delusional disorder, not ASD. Case-specific factors do not warrant defendant's exemption from capital punishment. Defendant alternatively argues he should be exempt from the death penalty because the intense media scrutiny on his ASD undermines his ability to present meaningful defense and renders it impossible for him to receive a fair individualized sentencing determination. What? The intense media scrutiny on ASD? Where? Where is that intense media scrutiny? Because I haven't seen it. You guys, the defense, and this is what I mean, you can't bring something to the forefront and then call foul. You can't use this as an argument because you're the one that brought it forward. You wanted to try and use it to your benefit, and it backfired. So now you're going to say that he shouldn't get the death penalty because the media has intense media scrutiny on his ASD? What boat did you fly off of? As the state points out, however, there is no precedent for striking the death penalty due to media coverage, right? Further, any concerns that arise from such media coverage can be mitigated through voir dire and from expert testimony and evidence during the penalty phase of the trial. Order. Based on the foregoing, defendant's motion to strike the death penalty autism spectrum disorder is denied. Didn't work. Nah. Like, they had to pick something that he could fake, but that they prayed could hold up as something that could release him from the death penalty, and it didn't work. It backfired. Okay, so it must be in the next one. This one. Last one, you guys. We're on the last one, and it's 11 pages. Because the judge calls him out and says, well, I've watched him intensely. I might have missed it in the last document. I don't know. But the judge says, I've watched him intensely during every motions hearing and everything, and I've never, ever seen him do any of that stuff, including rocking back and forth in his chair and having to lift an arm and turn his body. You know what I mean? Like, get the F out of here. Okay. The state seeks to prohibit the defendant from offering any testimony during the penalty phase in connection with his neuropsychological and psychiatric evaluations performed by his disclosed expert, Rachel Orr and Eileen Ryan. These are the two that we just went over. They can't use it. ASD is not an issue that can relieve him of the death penalty, right? State argues the proposed testimony falls outside the mental health condition evidence allowed. The defendant responds that he is not relying on the proposed testimony as a mental element defense, noting his relevant diagnoses are physical conditions, not mental conditions. But you're trying to get the death penalty thrown out for ASD. Doesn't make any sense. So if you do want to read through this, a lot of this we've already heard in court. Facts. During the course of this case, the defense team retained Dr. Rachel Orr, a clinical neuropsychologist, and conduct a comprehensive neuropsychological evaluation of the defendant and issue a report. She ultimately diagnosed the defendant with autism spectrum disorder level 1 without accompanying intellectual or language impairment, ASD, and obsessive compulsive disorder, among others. So if that doesn't work, let's try this. Defendant's OCD is manifest. Okay, so now she's saying they set up here that he has OCD also. So now they're bringing in OCD. Defendant's OCD is manifested through compulsive cleaning behaviors and taking precautions to avoid contamination. This is their way out, OCD. You can't prove whether you have OCD or not. You know what I mean? These are easy things that you can fake. Okay? So now we got to figure out, how do we just get rid of this evidence, right? Of me putting stuff in baggies and throwing it. But wait a minute. It says defendant's OCD is manifested through compulsive cleaning behaviors and taking precautions to avoid contamination, sickness, or germs. Or report on page 18. He excessively washes his hands and reported using gloves during basic everyday tasks. Although the defendant does not carry a current diagnosis of DCD, Dr. Orr opines that he met the criteria for the diagnosis in the past. Wait a minute. You see this? He excessively washes his hands and reported using gloves during basic everyday utility. Okay. So they're going to try and use this as this is why he was using. He had gloves on and was putting his stuff in little baggies. But how do you explain him not throwing it in his own trash? Why is he going over to the neighbors to throw it in their trash? Right? You can try and fake the OCD all you want. It still doesn't explain why you wouldn't put your stuff in your own garbage, that you would go outside of your house, down the road a bit, to go throw it in the neighbor's trash. Explain that. But this OCD that they're trying to bring up here now, saying he has this, is trying to explain away why he was wearing gloves and putting things in little bags and stuff like that. Well, explain why he went and disposed of it in the neighbor's instead of his own garbage then. Right? Although defendant does not carry, defendant's educational history, parent report. So this is what she relied on. And I think this one right here, that's his mother. So you got him trying to fake this ASD and this OCD. And then you got his mother coming in and saying, oh yeah, I remember now. He used to do this as a kid. He did this as a kid. He did that as a kid. He did this as a kid. He did that. He did this. He did that. Oh my God. Making me a pizza with pepperoni and extra cheese. Come on. Okay. So we know now that the parent had input. So the defendant's educational history, parent report, and evaluation results all provide evidence that the defendant experienced significant defects in motor functions in the course of development. So when he was a little baby, which in turn contributed to problems meeting typical motor and coordination milestones of childhood. He's not a child anymore. He's a grown-ass man. Example, he had problems catching balls, handwriting, and riding a bicycle. So did my kids, and none of them are ASD. A lot of kids don't have that coordination to ride a bike or to catch You know how many times my daughter got a bloody nose because she caught a ball or a basketball or something and it slipped through her hands or whatever and hit her in the face? Come on. While motor problems have not impacted his functioning significantly in many years. So none of this has affected him in many years. Defendant continues to present with impairment in fine motor dexterity and vulnerabilities in visual motor functions. Well, how do you do that? And you drive and you're a boxer, right? Evidence in his cognitive profile and observations of his behavior. None of this has anything to do with him being able to do these red rooms. Right? And while motor problems have not impacted his functioning significantly in many years. Yeah, probably since he's about 2. Evidence of ASD to explain demeanor is only admissible if the defendant testifies. So, do you remember Anne wanted the judge to tell the jury, look at, if you see him doing certain things because he's got this ASD, blah, blah, blah. Nope, not allowed. The only time that will be brought up is if he testifies. Okay, not one of the defendant's experts has ever imputed behavior to him that remotely approaches the odd behavior in Burr. Moreover, the court has had the opportunity. Oh, here it is right here. Moreover, the court has had the opportunity to observe the defendant through multiple hearings over the past several months, some lasting all day. Not once has the court perceived defendant to be acting in an odd or incongruent manner or otherwise demonstrating signs at counsel table that would warrant any explanation to the jury. His demeanor has been entirely appropriate. In addition, unlike in Burr, the state has indicated it will not present any evidence from witnesses about the defendant's alleged odd behavior. Consequently, testimony about the defendant's ASD is simply not relevant if he does not testify. Moreover, introducing such evidence risks confusing the issues, misleading the jurors, wasting time, and potentially unfairly prejudicing both the defendant and the state. If, however, the defendant testifies, evidence to explain his demeanor may become relevant. At that point, the defendant's demeanor, which goes to his credibility, is relevant evidence a jury can consider, which the state concedes. However, prior to presenting testimony on the matter, the defendant must raise the matter with the court outside the presence of the jury to discuss the permissible scope. Evidence of DCD or OCD is not admissible to rebut ability to commit a crime. As with the OCD, defendant argues he intends to introduce evidence of defects in his fine motor dexterity and visual motor function caused by DCD to rebut the state's evidence that it was possible for him to have acted with the speed and coordination acquired to commit the crimes. The state responds that the defendant is improperly stretching the bounds of his expert's opinion to reach an inference that cannot reasonably be drawn, which was not disclosed and which otherwise has no support. It argues that the evidence is not relevant to guilt and or barred by IRE 403. The state's challenge is well placed. Whether the defendant was physically capable of speed and dexterity to commit the crime on account of DCD is within the realm of expert opinion. However, it is not a diagnosis from which the defendant currently suffers. In a report, Dr. Orr noted DCD was a diagnostics for which the defendant met criteria in the past. See, right here. We already read this, but I'm going to highlight it again. While motor problems have not impacted his functioning significantly in many years. Nothing herein remotely approaches an opinion about the defendant's ability to commit the crimes. At most, Dr. Orr could testify about her observations about his weak fine motor dexterity and visual motor skills, but without any opinion tying this evidence to his ability to commit the crime, its relevance is lacking and invites unsupported speculation by the jury about the defendant's ability to commit the crime. Additionally, there is again the concern about the expert testimony will consume an inordinate amount of time on an issue for which there is no foundation in trial that will already be lengthy. Order. Based on the foregoing, state's motion to eliminate neuropsychological and psychiatric evidence is granted in part and reserved in part. There you go. So good luck with that, Anne. So that's it, you guys. We are at the end, 3.5 hours. So I've spent like 6 hours on this today. Because it did take me like about the same amount of time that it just took us to go through it. It took me to go through it this morning to get everything highlighted for you guys. It's a lot of hours. So what do you guys think? Do you think his goose is cooked? What do you guys think? I'm waiting to see what you guys are thinking. That's why he cleaned the crime scene. Chuck says AT is steering the bus, the FBI is driving the train. I love that. Thank you, Carolyn. Carol T. Carolyn. Cooked on low, yeah. I'm just interested to see what they are going to try and come up with next, right? I'm going to move this back over here. Oh, that's funky. I don't know what just happened there. Let me... Uh-oh. Oh, I gotta stop sharing. That's what I gotta do. Okay. I didn't know what I'd done there. All I seen was a whole bunch of... Nothing is left so far. I think the next... Let me just check my calendar here, because I think the next time they're in court is for the pretrial hearing. So let me just check and make sure. Okay. Yep. The next is May 15th, pretrial hearing. Which is, I'm going to be covering it, you guys. May 15th, pretrial hearing for Bryan Kohberger. I think, if you want my honest opinion, I think that he's going to try and get this delayed again, but it's not going to work. And for you still here, tomorrow, 1 p.m. Eastern, we'll be doing our live mini read. So if you would like your own mini read, come and see us tomorrow at 1 p.m. Eastern, right here. 1 p.m. Eastern, we'll be doing live mini reads for you guys. So if you would like your very own mini read, come and see us tomorrow, Sunday, 1 p.m. Eastern. So yeah, that's what's next. What's left for them to try another motion? I don't know, Carol. It's like, what can they throw out? Like, I know there's certain things that are easy to fake. And then when you got a parent that says, oh yeah, but that's when he was like, what, 2, 3, 4 years old? Because now he can concentrate, because look at all the degrees he's got. He was going for his PhD. He was a teacher. Well, if you want to call him that. He drives. He lives on his own. He's high functioning. There's nothing, he boxes. Like, come on. Come on. Like, he had friends that, that he had that are no longer friends because they were afraid of him. I don't know if any of that's going to come in, but we did hear from quite a few people that knew him that, they were threatened by him. And he had taken up boxing and everything. Like, you need good coordination and quickness for that. I'd like to know, what led these friends to be afraid of him. Did they see him fight? Did they see certain things where he grabs somebody really quick, works on a computer? Yes, Carol? Look at that paper that he typed up. He can't concentrate. He's disorganized. What? The prosecution at this point has so much that throws everything that they just said out the window. Somebody who's disorganized in that, I'm telling you, going through any kind of legal schooling, I know because I did it. I had to go through 6 years of schooling. It's hard, and you have to be organized. You have to be focused. Like, there's no way. There's no way that he has ASD. Not in the way that they're describing him. Somebody who's not organized is never going to get through, especially as far as he's got through. Right? And be able to type up that paper that he had to submit for his finals. Like, good luck. And from what I'm understanding is it's beyond the part of a deal now. I know there's certain family members that have said, no deal. We want the death penalty. No deal. So we'll have to wait and see what happens, you guys. It is pouring down rain outside. Okay, so we're going to wrap it up, you guys. I've been here almost 4 hours. I think I've taken enough of your Saturday, and I've got to get something to eat. So we're going to wrap it up again. I'll see you guys here tomorrow, 1 p.m. Eastern. If you want your very own mini read, come and see me, 1 p.m. Eastern. I generally put the thumbnail up at around 10 a.m. Eastern, so you can set your reminders in that. So with that being said, you guys, I'm going to let you go for now. Thank you for being here. Thank you for reading along with me. I did scroll through the pages, so if you do want to go back and pause and read everything that's in there, I gave the overview, which was 4 hours, right? Almost. So thank you for being here, you guys. I'm going to end it like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. Bye-bye for now. Love you too.